in the process of being filed.
All right.
Hey, everybody. What are we talking about? It's filed. Chuck Cook here. John Amain Bailey. Got Greg Siskin back from his bike ride across Iowa. Welcome back, Greg.
It's good to be back.
Waleed Nasser. Waleed, I need to get you to get a better screen and get you a better camera. I think we can afford one for you. And then, of course, Jeff is with us today. It's great to have everybody here. So we just got done with oral argument in our temporary restraining order case in the Liu H-1B lottery abuse case. Waleed, how did that go today?
Not as we expected, not as we hoped, but we went down swinging, and I think that in the long run, we definitely planted some seeds for the judge to consider.
So the TRO, when you ask
for litigation, this litigation is not over.
Yeah, when you ask for TRO, it's a really high standard to get. I mean, they're very infrequently granted, but we felt we had to do this because the lottery came out. I was going to say this, but there's a line of being an aggressive, good lawyer and being a jerk. So there's certain things you don't say. It's like, gee, judge, they purposely ran the lottery after we filed the PI so that we'd have to come here on a TRO. You just don't say stuff like that in a hearing. So, although I think they did do that. But this step one. The preliminary injunction is still on. The preliminary injunction hearing is the 27th. Now, tentatively, that is a Friday afternoon at 3 o'clock in Washington, D.C. in August, right before, if I'm not mistaken, the Labor Day weekend. Am I mistaken about that? Is that Labor Day weekend? That may very well be. Let me check. That may be. No, it's not Labor Day weekend. It's the next weekend. But still, nobody wants to be in D.C. on Friday at 3 o'clock. So government counsel and I have talked. We're probably going to move to do it by Zoom because government counsel is in Chicago. So he doesn't want to have to come to D.C. either to do it in person. And we were just fine today by phone. We'll see if the judge can do it by Zoom or by phone, either way. We also may postpone it because the purpose of the preliminary injunction was to really, hey, let's get a decision quickly so we can affect this year's lottery. Well, obviously this year's lottery is not, I don't think it's over. Doing the math, I don't see how they selected enough people yet. I don't
think they did either.
That would be 11,000 fewer people than they selected last year. Now, are they saying the denial rate's going to drop that low? If their denial rate's not 35%, yeah, they probably have enough. But are they really going to go below 35% denial rate? They clearly haven't adjudicated enough cases. As I mentioned in our argument, there's no way they could have adjudicated that many cases yet. So we got to PI. It'd probably be around that. We are going to amend the complaint. We'll be talking to our plaintiffs. We'd like to get a employer plaintiff. So if any H-1B clients listening now and you have an employer, doesn't matter. It could be any employer, anybody that's filed for you. That would be really nice to have. And that takes care of one big issue that we don't have to deal with at oral argument. I still think we're in solid shape. I think if we weren't in solid shape, the judge would have tossed it today because he has a right to do that. But I think we can plug what the government and thinks may be a hole, and we can go to the merits of the case. But I think it's still a good case. The reality is, remember we talked to everybody. This goal was try to save this year's lottery, but really, ultimately, it's about next year's lottery. And we have sent a gigantic Goodyear blimp message floating over USCIS headquarters. And I know there's people in Congress that are looking at this as well for some congressional hearings. So that's really the purpose, to get them to fix this problem for next year. I did warn government counsel, and I didn't even say to the judge, look, if you don't fix this, my guess is you're probably going to have about 500,000 applications next year. Why not? Why not get as many employers as you possibly can to file for you? You'd be stupid not to, right? Yeah. So, play the game everybody else is playing. That's what happened this year. All right, so that's the H-1B lottery case. We're moving along. Jana, you've been working on the EB adjustment of status delay case.
I have been working indeed. So the complaint is ready and has been handed over to Jeff, who is newly admitted to the, oh, am I glitchy? Jeff, who's been newly admitted to the district court in Maryland. So I believe he is working as we speak to ensure our EB adjustment of status case can be filed. That was complete last week, and I know we were hoping to file last week. We were waiting on the court there to physically, manually allow Jeff to electronically file. Surprisingly, that's not an automated process. It's has to be waited to be sworn in, and then a clerk has to physically allow him electronic filing abilities. So,
and I have the secret code now. I have the secret electronic ability, and I'm in the process of entering the 125 plaintiffs' names into the computer. So I'm going to now mute myself while I continue to.
While Jeff gets back to work.
Could be finished by the end of this YouTube. We could have.
It could very well be. And we can give you everybody a case number. If we don't have it by the end of this video, we will post it on the Twitter and email out to clients. We will have to redact the complaint because, Jana, the complaint has lots of people's names in it, doesn't it?
Yes, it does.
Yeah, so we'll have to read. That'll take us a day or so to redact that so that we can get that out to plaintiffs. But, Jana, tell us about the case. What is the crux of this complaint?
Well, we threw lots of arguments in there. So there's the argument that these cases that were filed in October have been unreasonably delayed. And that's based on a case that says, technically immigration petitions and applications should be adjudicated in 180 days. So this is under the mandamus relief that we're saying, it's long past that time. Lots of people took months to get their receipt notices. Lots of people are still waiting for biometrics or fingerprinting appointments.
And Joanna's video does cut off.
This kind of delay. Yeah. Am I freezing again? I'm sorry.
You're freezing again. Are you in your basement? Where are you, Jana?
No, this is the middle of Memphis, Tennessee, and yet internet providers at my house, not so great.
Yeah, well, you should. If you think it's bad there, you should come to my farm in rural East Tennessee, and you can hear about the rural-urban broadband divide.
Oh my! Okay,
have to be fixed.
And yes, with $50 billion. So hopefully Volunteer Electric Corp can get some cash from the Biden administration.
Fix the Midtown Memphis problems too.
Right, John, continue. So that was when. So you were talking about a reasonable delay.
So similarly, we're arguing for unreasonable delay. It's a similar argument, but made under the Administrative Procedure Act. So this is important because it's basically another opportunity for us to argue that these delays are unreasonable. And it's unreasonable because when you look at the processing times on
the USCIS website.
USCIS. 52 months, that's the highlight.
Yeah, well, think about that. So I want to ask Greg this question. Greg, what's a reasonable time to adjudicate an adjustment of status application?
Not 52 months.
No. I mean, well, we know that it takes, 98 minutes of adjudicator time?
What they said.
So
well,
I would say 30 days, to be honest, on there. But the, historically, 6 months was it was not unusual for an adjustment application.
Yeah, Jana did a great job in the complaint tracing the delay and the growing delay over the last decade, 15 years. And I think the point is this, John, it's got to remember wrong or not. Just because immigration says it takes 52 months doesn't mean that's reasonable.
Right.
No. I mean, that's really the key. They don't get to set the reasonable standard. That's actually set by, anybody been to law school, the reasonable man. Or the reasonable woman in this case. So you got that complaint. Now, there's another big part of the complaint besides, hey, adjudicate our freaking applications. What's that?
Are you asking about my creative argument or the fact that we said in alternative you can reserve those adjudications to preserve them for this fiscal year counting? So,
Jana, you're killing us.
We did ask.
John, we're losing. We're losing. Maybe, hey, John, turn you off your video.
Okay, I will.
And maybe that'll help a little bit. Now go ahead.
All right.
So, Chuck, two more things that we asked for in this lawsuit. First, for adjudications that are going to take beyond October 1st to be reserved and credited towards this current fiscal year to enable those applications to be approved to prevent the retrogression. So we also made a very creative argument. So that I'm going to just briefly highlight. If anybody else wants me to explain further, I'm happy to do that. So we made this creative argument, and this is based on the way USCIS credits the numbers when a case is either filed or approved. And I use those two time frames because this language is the same in the the statutory language is the same for both H-1Bs and for the
adjustment of status
applications, both employment-based cases. So this is interesting because in the H-1B context, you file a petition and your number or your visa is reserved at the time of filing. And if that petition is ultimately denied, effectively that number is returned back to the hopper to give someone else an opportunity for that approval.
Donna, that was verified today in oral argument by government counsel. So we actually have government counsel on the record saying that today.
I need to figure out the Bluebird book way to quote government counsel in these federal cases. Contrast to the way that numbers are accounted for in the adjustment of status context. As many of you know, when you file your application, they first check to see if the filing is timely, either some. So you have to effectively have a number available at the time of filing, but again, at the time of adjudication. So this is interesting because, if USCIS is taking months upon months, there can be significant change in the visa bulletin for a particular applicant. And this is also significant when we're, facing a dilemma like in 2021, where we may lose significant employment. Say it again, Chuck.
Yeah, Johnny, you keep cutting out. So I'm gonna stop you right there because I want to ask Greg a question. It goes directly to your point.
Sure.
So, Greg, the visa bulletin, when Charlie Oppenheim releases the visa bulletin each month, and he gives a date, a cutoff date, within what period of time does he believe that people that that have a credit before they are going to be adjudicated?
Prior to September 30th of the end of the fiscal year. So
when he sets a date, that means within that year, they will be adjudicated.
Right.
So there is your reasonable standard set by the government itself. And here, things do happen. Because one of the math that he does, it's complicated. And I should show you one of the exhibits one of our clients gave us in the H-1B litigation is 10 pages of math. But he has to account not just for how many applicants, how many visas, but for usage, because not everybody that's in the line is going to get their even apply for the green card. So sometimes high demand, this is more true in family cases than employment cases, they just don't show up. You move a date forward,
or they're
denied, and we're a high denial rate. So that's a key part of this litigation that John is talking about is they're supposed to do them within this fiscal year. Now, John, if you're back, could you talk a little bit about the reserving? Why are we reserving these?
Sure. So we're asking for reservation, and the CIS recognize that adjudication is not going to be feasible in the next 60 days. So we're asking for a reservation so that the numbers or the applications adjudicated can be credited to the current fiscal year, effectively preventing a rollover and a loss of those numbers.
Great point. And this is why we're going to be filing a preliminary injunction, because those dates are going to be exhausted here relatively soon. Now, Jonna, could the Immigration Service moot this case by approving all our clients by September 30th?
They could, and we would love for them to do that. That being said, I'm pretty committed to this interesting argument about the time of filing. So I would love for the judge to make a final ruling on that. So I don't know that they can completely moot our lawsuit if we're really interested in pushing that. But certainly on the mandamus and the delay. We would love to wake up tomorrow to hear all of our plaintiffs having their green card applications approved.
This also goes, why we're asking to reserve these numbers. There was a great article in the Washington Post last week from our friend David Beer from the Cato Institute complaining that immigration was going to waste more than 100,000 EB numbers because of their essential incompetence and mismanagement. And I thought, I don't know if, Greg, you had a chance to look at that article while you were bicycling, but he's low. There's no way they're going to adjudicate 140,000 green cards for employment-based cases this year. As of, I think John pointed this out in the complaint, as of March 31st, 50% for the fiscal year, they'd only approved 37,000. I mean, how are they really going to approve on 100,000? I mean, I don't know about you guys, but I haven't been flooded with employment-based adjustment approvals, even though we have hundreds pending the last quarter. So clearly they are not working these cases. And what's interesting is how many of the approximate 300,000 pending EB cases, more than half are at district offices. Only half are at service centers. And so the district offices aren't clearly adjudicating those. They're going to focus on naturalization cases. So think about that. There's 300,000 pending cases. There's probably about 200,000 visas that haven't been used yet. So you can literally basically approve 70% of pending applicants by October if you were doing your job correctly. And then as soon as October 1 hits, you could get all the rest done so that every employment-based adjustment applicant would be adjusted by October 2nd. Think about that. They'd all be gone. There would be no pending adjustments. And you can move the date forward by years. And you could get all these people waiting in this terrible backlog, their kids aging out. You could get them green cards without screwing with the numbers. I mean, even though you should add more numbers. You don't need to if you don't waste it. That's why this lawsuit's so important. John, I'm looking forward to getting the government reaction to this one.
I am as well.
All right. Oh, you know what? Lily's going to kick our butts. She's going to kick our butts. We did not put up the tags, so we just finished. Sorry. I'm just coming off a high. When you do oral argument, you get a high. It's kind of like a buzz. You come down, your brain kind of goes away. It's like, oh. Greg, you will know that today's oral argument was with our friend Joshua from the lottery case.
Okay.
So that was today's oral argument. It was good. All right,
let's kind of walk. Chuck, you kicked butt.
No, we had fun. It was it's sad not to prevail on this, but not disappointing because it wasn't unusual to lose a TRO. I feel very good still about moving forward here. We're going to keep fighting for these folks because it's the right thing to do. The right thing to do. All right. I have a couple updates on some litigation. Milligan, Lily told us. What did Lily just tell us? She couldn't be on tonight. She told us that. She did. Let's skip. Actually, I don't have an update. She didn't give me a Milligan update.
I tracked Milligan, Chuck.
Okay, well, that's right, John. Give us a Milligan update.
Yeah, largely we're still seeing round 2 and 3 folks getting successful news. We are familiar with those of you who have submitted updates who haven't seen progress in your case, so we will continue pushing for those to get resolved. But thank you for the updates. We are seeing those and trying to troubleshoot the couple cases that are still stuck. And
we've had a few folks. I think we heard from somebody that was round 2 that just everything's done, and now they were told they're in administrative processing without sort of any clue as to why. If that is your situation, my recommendation is to give it about a week to 2 weeks to see what happens, because some of these administrative processing, some people are being put in administrative processing for very not concerning reasons and some of them only last a couple of days, like 2-3 days, maybe a week or two. So Chuck, I don't know if you have a recommendation here, but I would say probably don't hit the panic button or worry too much about it. A week to 2 weeks, probably, I would say let that period go after you hear that news to see what happens. it seems like a lot of folks during, if they wait a week to 2 weeks, then the issue goes away.
Yeah, I mean, unless you're from one of the 35 countries that Trump doesn't want to come from, generally administrative processing is pretty quick. Some issue on your case, or as was pointed out in one of our prior talks, it could just be that it's change time at the consulates in July. And somebody said, I'll wait for the new guy to take care of this when they come in, if you recall. And on the Milligan case, we're still waiting on the judge's decision on the government's motion to dismiss so we can move forward with the motion for summary judgment. So that's kind of still out there on Judge Boasberg's calendar. On the, let's see, where's the other case here? Kinsley. In the Kinsley case, Lily said people are still getting visas and interviews scheduled, kind of the same thing that's happening in Milligan. On the Manila case, we are getting people interviewed little by little, not huge chunks, but little by little. And again, we're waiting on the court on a lot of these cases. So that's kind of where we are on those couple of cases. Let's see. And that's true on London as well. People are London, she said, a few cases got transferred from the National Visa Center, but most of our clients' queries to the NVC consulate are getting ignored, which is not unusual. But again, the litigation itself is moving forward on these cases. Let's talk about Go. Aaron's not on. I'm missing Aaron. Is Aaron on vacation, Jeff? Jeff's working too hard. He didn't want to know. I wonder where Aaron is. I wanted to have Aaron talk about the Go case. The government filed a response to our filing on standing. It's a nice response. We don't believe it changes anything. We are not inclined to file a reply brief. We're going to consider that tomorrow when Aaron and I talk, but our clients have standing. The argument that they don't have standing is ridiculous, honestly. So we feel very confident about that Go case, and we move forward. If you recall, there is another litigation pending. That's a class action. We've heard nothing more about that as far as what the judge is going to do, what the government's going to do. Nothing. And we reiterate to our Go plaintiffs that we do not think you need to be in a class action. If you want to be, let us know. We'll dismiss you from our case, but not until there's actually a class action. And for those of you who aren't our plaintiffs, understand that we believe our Go decision will in fact be a universal decision, but which our clients get priority to get their visas issued because they are the plaintiff. So if the judge rules, because the key ruling is you can't not issue these visas, and your failure to do so negatively prejudiced these 1,000 plaintiffs, adjudicate their cases, and you could reserve just visas for our clients, but more than likely, given the nature of the litigation, he's likely to reserve visas. Hopefully, my argument was for everybody, reserve every unused visa, and we go from there. But we have had, Greg, a number of our clients, several of our clients have been interviewed and gotten their visas. Woo! Others have been scheduled their interviews, and there are a lot of consulates that are scheduling out up to and including September 30th.
And there's nothing left. There's nothing left for us in the case to file or do. I mean, we're just in waiting mode right now.
Right. We could file a reply to the standing brief, but honestly, I just don't see that that's necessary. And I don't see us. Oh, John has changed position. Different room in the house, it looks like.
Different room in the house. I got closer to the router.
Oh, there you go.
I'm sorry.
Yeah, that's actually much better sound from you. So on the Gomez case, Greg, I've gotten 5 emails today and DMs. Mr. Cook, when is the judge going to decide? So
it's going to be at the same time as Go.
I don't know.
But I mean, we're not expecting a different timeline than Go on that, are we?
It'll be the exact same time. They'll come out together.
Yeah.
In many ways, they're very much companion cases. Now, remember, the great thing about our Go case, ours is a final judgment. We don't have to go back to the judge years from now and dork around like we're doing in Gomez. We're getting a final judgment. hopefully with some follow-up from the judge over the course of the next several weeks. So, awesome. K1 Cairo, we need to hear, do we have any update from our clients about the interviews that they're supposedly getting set for? I mean, all the cases are at the consulates, and the K1 is supposed to be at least a priority 3, if not higher. So hopefully they're hearing. Oh, K1 Moscow, officially today, the U.S. consulate fired all Russian employees. That means nobody's visa is getting issued in Russia. So Waleed's back. So nobody's visa is getting issued in Russia. And that actually we actually, you know what? We may file in the Go case that information, because I brought up an oral argument. State Department's made no accommodations for these people. Nothing. And there's something like 3,000 winners from Russia, and they've known about this since May and done nothing. I mean, it's not as bad as Afghanistan, but it's pretty darn bad. It's pretty darn bad. So I think that kind of covers all of our cases. So let's take a look at some of the comments here. Ankur Shah, Ankur, I hope you're doing well. What can we expect on the case next? Well, no, the case is not dismissed, just the TRO is denied. So we have oral argument on August 27th on the preliminary injunction. And we'll be working with the government maybe to figure out how we're going to do that in a more effective way than flying to DC. So the decision moves on. And remember, part of this goal in this case was get Congress's attention, get CIS's attention, and make sure next lottery doesn't suffer from this. And who knows? The judge might change his mind and say, you know what? I think immigration really did screw your clients here. So I'm going to order them to reserve certain numbers. So we'll be working on that with the judge coming up. K1 Patrick, hope you're doing well. K1, will all 3 judges in K1 no? This is a great question. Jeff's too busy typing, so I'm going to talk for them. Talk for Jeff. The judges don't collaborate. They don't call each other and say, hey, if you do this, I'll do that. I've never heard of judges doing that. I don't think that's proper. I think that's undue influence, and the judge is not supposed to consider anything outside the 4 corners of the case. So no, I don't think that will be happening.
Well, they can pay attention to a ruling in another case, can have an influence on a judge.
If there's a ruling, but
Right.
if there's no ruling, they're not going to coordinate it all coming out at 5 o'clock on a Friday.
No, that's right. That's for sure.
And if you've noticed, a lot of rulings come out at 5 o'clock on Fridays. All right. What? Anyways, EB, any chance plaintiff's case looked at? Yeah. I mean, we're actually asking for that, and we will be asking for that in the preliminary injunction. Which is why we wanted all your details, all your case numbers. So as you heard today, immigration looked for registrations from our plaintiffs, but we didn't give them all the registrations because some of our plaintiffs didn't have them. Bing Wu, we need spies to gather evidence from those fake companies.
I don't think we need spies. They're all over the internet.
We've got some. I mean, you don't have to fake anything. Yeah, the fraud is out there for everybody to see. Some of you have been great. Thank you, Bing, for bringing that up. Thanks for hard work. It was delay case. The plaintiff whose PD is not current. Benefit from this case. No, they can't adjudicate you if your priority date is not current. But think about this: if they used all the visas, then the priority dates would shift forward dramatically. Right? So you do benefit from the case as well. Chris Damianis, H&B case. It's already been denied. When will the PI hearing start? August 27th, 3 o'clock. Direct relief if you win cases. I mean, will you get picked in the lottery? No, that's never been part of the consideration. The judge cannot manipulate the lottery for you. What we're asking the judge to do is make the lottery fair. I mean, you've probably heard that from the judge today. I mean, he can't select you in the lottery. Waleed, we need to get you better internet reception here, or get you off your phone and into our firm internet. So no, there's no direct benefit in the context of you're getting selected in the lottery. Bing Wu, you already said this. We're going to get this. Mr. Shi, PI asked for the secondary law. We're going to finish. Well, except, as we talked earlier, did they pick enough people? And you heard the government say, if we deny your case or we revoke your case, the number goes back. Now, I will tell you, that has always been unclear. And in fact, they have specifically refused to answer that question in previous years because they have every year since 2011, they've maxed out the lottery. And they didn't ever come back and say, hey, I got about 10 cases that were revoked in August. Let's have another lottery. They haven't done that, have they, Greg? They just burned the number. So this is an interesting thing. So we don't think until immigration confirms that all 85,000 visas have been issued. No. Oh, an interesting factoid, and I think Greg particularly will find this interesting. They disclosed in their affidavit from the acting associate commissioner director for Service Center Ops that 48% of the filings were for master's degree cap.
Yeah, that is interesting.
That is a stunning number. Think about that. We have 150,000 master's caps people. Now they're not stuck to the 20. Keep in mind the lottery is run generally for the 65,000 first, and then those masters not picked in that then go into the master's lottery. So it's not just a random selection as far as in one shot 20,000, but well below half, probably 30-35% is all that's getting picked are master's people. That's a sucky way to run a country. Telling advanced degree people to go home, that's just stupid. That's a stupid public policy position. Let's see. You already asked that question. Bing, you already asked that question. We got a lot of multiple questions. So Chris, don't feel sad about the TRO. We still got time left to fight on this. Russ Volvo. Russ must love Volvos, is all I can figure. Or he works at Volvo. Britt Simon thinks the GO can still get priority. I do. We are the final decision case. We are the only one. So I do think we get priority, and I just can't promise that. Can we promise that, Greg?
No,
but I still think it's likely. And remember, again, last year in the Gomez-Acker case, all of our clients were scheduled before the end of the year. So they didn't all get visas, but they all got scheduled. What are the chances in the DV lottery case haven't been confirmed? Again, because we're seeking a reservation of visas, it's fine. They're not going to be able to get everybody done. They're not going to get, last week we talked about them setting about 6,000 appointments for 11,000 people. They're not going to set more than that. They're just not. So that's going to leave 45,000, 43,000 numbers. And we still think the judge has got a legitimate reason to reserve all of them. Today, a Facebook post was made saying someone had their lawsuit rejected because the embassy was moving again. Honestly, without actual facts, it's impossible to comment on that. I don't think the London mandamus is going to get dismissed by the judge. But again, our London plaintiffs are moving, which is a good sign. Penn plaintiffs here. Who can get us copies of the government's responses in the case? Motion to dismiss. Pay for them on Pacer. You don't have to pay for them on Pacer. Greg, is our website pages up, or John, is our website information email out to people?
So there was a motion today that was approved, and I do need to pass that on to the Penn plaintiffs. So I believe the question may be referring to the motion to incorporate the plaintiffs from the original complaint that were left off, and that was accepted and approved. So we are back to where we are needing to be in terms of all the plaintiffs are on the case. We are waiting for the judge, and you are right, James. I owe plaintiffs the redacted version of that judge's order.
And the maybe resend out links to the motion to dismiss, our response, and the replies. Everybody has those. Okay. Yeah, you don't pay for those on Pacer. We do have web pages for each case coming up. Greg, any idea where we are on that? Greg just got back from riding across Iowa, like 20 minutes ago. So
I don't know. Jeff actually may have a better idea of when we're going to go live with the impact litigation site. It seems like it was making some pretty good progress, but I don't know. I don't have a day yet. And when we're
I know Kirby met with them yesterday, but I'm not really sure the exact date. It should be soon.
all right, good
once
there.
we have that, we'll have a lot more information on each case there once we have that new site up.
Gorky, good question on the D. Every time I see DQ, I don't think of documentarily qualified. I think first of the Blizzard, perhaps one of the best fast food things ever done. Second, I think of disqualified. So DQ is a terrible acronym for those of us. Keep in mind, the ACCR people weren't all documentarily qualified. You can be documentarily qualified at the consulate. KCC does this as a matter of convenience for the consulates. Consulates are fully capable of doing it themselves. So there you go. Did the TRO get denied because the case is tricky? No, the TRO got denied because the standard is so high that the judge didn't feel like we met the standard to put an injunction in place immediately without further briefing. And of course, it's a complicated issue, but it's not because it's tricky. It's just that it's, as I mentioned, it's immigration law is crazy. Any updates on H-4 EAD delays? Well, we're not litigating that issue because honestly, it's a quirky issue that's been lost and won all over the country. And
yeah, and our friends at Wasden and Banias have been litigating that issue, and it seemed like they. I mean, are they? And is AILA separately litigating that issue, or is it just?
No, I don't think AILA is separately litigating that I'm aware of.
Oh, so yeah, I mean, but it is an issue that is being litigated. It's not being ignored. It's just that we can't take on every single issue and sue on everything, and that's one that
we would love to. We would love to, but we just can't. All right. The TRO does not affect the PI case because, again, it's a different issue. The facts remain kind of the same. The arguments are under a different standard, however. So there we go. And Mr. Liu, if you've got a plaintiff employer, that would be great. Give us a call. We'd love to have you. Let's see. How many plaintiffs joined the EB-IV delay, Jana?
The final count was 125.
There you go. So we got folks. All right.
If you did not join, you can certainly go to the litigation website and join the waiting list. If and when we add additional plaintiffs, that's the first place we go to notify those on the waiting list. I'm not sure if we will do that, but if you want to join and did not, that's the place to go.
What is the deadline on the court deadline on adding plaintiffs that without having to get the government's consent?
14 days. Is it 14 or 21? Now
I believe it's 21 days, but we're going to be filing the PI before then, so it's very quick. If you want in, you need to get in.
Yeah.
Okay.
Mike Holman, I'm not surprised that the Delta variant is striking havoc in Manila. This sucks. But that actually is something the court will not order them to work to do, is to reopen during a government shutdown. Is Manila shutting down or just the consulate shutting down? That's what a little unclear. Yes, Natalie. I'm sorry, Natalie. It's my fault. Will USCIS get any penalty for ignoring the PI? Well, that's what we're going to be asking for. What we didn't get in the TRO filing were exact numbers. How many have they approved? How many were duplicates? How many were denied? We don't have that. And so in fact, we're probably going to ask for an administrative record in this case to get those numbers from the Immigration Service. So thank you. Let's see. If Judge Mehta gives go preservation, will it cover DV derivatives that age out after? Greg, do you know the answer to this question?
Judge Mehta gives go will it cover derivatives that age out after September 30th. I would think a judge can do anything he wants.
We're just going to have to make him aware of that. The Child Status Protection Act does apply to diversity visa applicants, if I'm not mistaken. So as long as you started the process, I think they're okay. That would be my argument if I was your lawyer. Okay. But of course, they're supposed to be handling age outs. So you need to be on the consulate case. Let's see. NVC said Rio is still not accepting K-1 visas. Well, again, that's why the lawsuit's pending. Yet Rio just interviewed one of my EB-5 clients on Friday. Can you explain
Chuck,
that?
On the K-1 country cases, are they all outside the 60 days now from filing?
Well, many of them have motions to dismiss pending. So I think there's still one, which is I don't think London's outside the 60 days. I could be wrong, but I don't think London's outside that. Let me check that really quick here. I can't do that when I'm kind of on here. Sorry, but I don't think that's out that.
What are you looking for, Chuck? I can look at it.
Whether the London case is King, that's the King case. Whether
King?
that is King, yeah. If that is,
Manila is where, and maybe you can mention for the Manila folks where we are stage-wise.
yeah, the motion to dismiss is pending in the Manila case, so we're just again waiting for the judge there. Let's see. Oh, I do want to give a shout out to one of our DV applicants, Francois Gilbert, who's in ICU with COVID. So we're praying for you. We our best thoughts are directed towards you, Francois, to beat COVID and get out so we can get your green card through the lottery. This is we're definitely praying for you. Okay. Let's see. Should travel
amended
DOS
complaint King was filed on July 19th, so we're still like 45 days out.
No, because the amendment. Well, that depends because there's still. I know 90 days haven't run yet, so we're still good there. Urshad, should travel DS be a defendant in EB case? No, not necessary. Because we're challenging the USCIS usage of this. So we think we're okay in not having Department of State as a defendant in the case. Please, did the government respond to the GO supplementary filing on standing? Yes, and it came in on the Friday night, and we'll get the redacted version out. Okay, you'll get all that. We'll email that out. I love how you people love reading the government filings. I just love that. I detest reading government filings, but that's just me. It's not high on my list, my hit parade. Are there any reason why Ramirez K1 are getting interviews while Milligan round 2 are not?
He's talking about Filipino.
Right, the Kilvin K1 and Filipino Milligan. It's probably the only thing I can think of is they're looking at file order, which I don't think is accurate either. But I can't give you an explanation other than that. Who will be arguing the EB-5 AOSDA case? We will let you know when we get ready for our argument on that. This has really been truly a team effort on this. Jana has done yeoman's work, and that's another American colloquialism, probably stolen from the British somewhere.
I'm happy to say that the case of I have to pull it up so I can say that right. Chakrabarti versus USCIS has been officially filed.
Sweet. Woo! Awesome. And Jeff, when you get the electronic notification, we'll share that with us, and we'll make sure that notice goes out to all the plaintiffs as well. Okay?
Will do.
Chuck, I was going to rewind to the question just before this, asking about Milligan versus the Manila case. And I was just going to give some encouraging news. We did just get around to Manila visa approval. So it is happening. I know it's slower than the other consulates. So use that as your point of encouragement that, things are progressing there, although Manila is very, very, very slow.
Here's Waleed, not our Waleed, a different Waleed. Greg, how many cases do you think are in Montreal for the DV?
You can probably count them on two hands.
Yeah, there can't be more than 20. They just can't be. The fact that they obstinately refuse to interview them is beyond me. I will tell you, Greg, I guess, so I had a client doing a family-based green card in Montreal. So he went to the embassy. He went for his interview about June 1st. And it took them until last Friday to issue that visa. Even though early in July, they said, oh, you're approved. They kept saying, we have to print your visa. I mean, isn't that a button on your computer and the machine in your office? I mean, really, are the mice broken that run the wheel that run the copier? I don't know how that works. Let's see. Oh, I jumped ahead all of a sudden. I didn't mean to do that. Let's see. A lot of the same questions we already answered. So ese es un demandante Kennedy. Yo no sé, hermano. Tiene que esperar. Let's see. Why is there a lawyer firm posting a video by K1 so they go to let all the K1 cases time out and people start over? They're losing. What? There actually is a lawyer that put that on a video? Well, I can tell you that there is zero chance that would happen to our plaintiffs because the judges would go nuts if the government did that. So no, I think I think the word I'm looking for is hooey. That's hooey. To quote my father. Greg's laughing. When's the last time you heard anybody use hooey?
I mean, we have had confirmation from the Justice Department already previously, because we did have a couple of consulates tell people that their cases were being denied because they were hitting the 1-year limit, and they quickly backtracked on that issue. So I don't, it would be nice, I think, if the State Department put out something publicly letting people know not to freak out over that issue. But we've at least, when it's come up for our plaintiffs, it hasn't been a problem after we brought it to the attention of the government lawyer.
So that's just not a thing. Rio, just to backtrack, Jeff, if you didn't hear, the update is it's pending. We're still waiting on the judge. The Algerian King Kong wants to know about the unlawful visa prioritization. That would be the Kinsley case.
What's the difference between the Algerian King Kong and the one that's from the island?
Where is King Kong technically from?
He's from Kong Island or whatever that was.
Is he from Skull Island?
Skull Island.
Is he from Japan? Where is Skull Island? I simply don't know.
In the ocean.
I didn't think he was from Algeria, though. It's the last place that I would have thought he would have been from. So in this question is really about the Kinsley case, and we are literally waiting on the judge. Joint appendix is in, and we're just kind of waiting in that case. So we'll see what happens. Let's see. Sydney Embassy unlikely to open anytime soon. Yes, that sucked, which is why we've got the multiple consulate closings. Now I'm thinking about this and hearing about it. We'll file a supplemental reply and go just to say, Judge, just FYI, reservation is becoming more and more important because COVID is forcing these consulates to close, and there simply might not be enough consulates open for us to be able to get these cases adjudicated. Okay. Let's see. John Doe, who doesn't want to be identified. I agree. The judge and government counsel and I talked afterwards, and this is why TRO is so hard, because the judge, he looked at the stuff probably in the 20 minutes before the hearing, doesn't do immigration work before he became a judge, and he's like, what's going on here? But we explained as best we could in the short time that we had, and that's why the PI is a much better opportunity for us to have argument. Okay. Let's see. Do I think something will happen on August 27th? Well, August 27th is a different case, Ryan. It's not the Go case. And I do believe the judge will rule before then. We're not taking any bets. We learned that lesson, but kind of where we are. Let's see. What happens if I'm scheduled for an interview in late September? I get AP, I don't get the visa. Well, this happened last year in Gomez. And one of the things we're asking for in Gomez that they're asking for is all those folks on AP would obviously be considered first for the lottery numbers that are reserved. That makes the most sense, I think. Let's see. A lot of questions here are just duplicates. Let's see. CB Man referring us to closing St. Luke's in Manila. I don't know what St. Luke's is. Is that like an economic zone? Is that a hospital? Here it's a hospital. So I don't know what St. Luke's is. I just don't have.
I'm guessing that's where they get their medicals.
Oh, maybe that's possible. But they're announcing they're closing in 3 days. That's kind of odd too, don't you think? So that kind of does it here. We leave with Andre, keeping our fingers crossed with Judge Mehta. Has discovery been filed? Discovery is only available after the motion to dismiss as part of our preliminary injunction that we'll be filing thereafter. All right, everybody. Man, I'm tired. I'm tired. And you all tired of waiting, and that's why we keep fighting even though we're tired. It's like Greg is refreshed after biking across Iowa. How many miles, Greg?
459.
You are the man. And Jeff's back. He's refreshed from vacation. He's good to go. John is going to now dive into the preliminary injunction, get that ready to get going, and there we are. All right, everybody. We will see you next week. You guys hang around for a second. We'll see you guys next week on Monday night. Tomorrow is the Facebook Live for Greg. You have Facebook Live tomorrow, I think.
Yeah, I will have it at lunchtime, and then hopefully I'll be feeling a little bit more refreshed then.
And Jeff and I have ours on Wednesday at 2:00. We've got one on Thursday at 2 and Friday at 2. Thursday is usually in Mandarin. And I'm going to try to get Waleed to do Fridays in Arabic. Woohoo! Waleed, you ready to do that in Arabic?
Oh, God, no.
All right, we're going to get Waleed to do that. Maybe we'll get him on board to do it with you. That will be awesome. You guys have a great week. Thanks, everybody.